All right. Thank you for attending our webinar this afternoon. My name is Patricia Fraun with the Chicago Area Fair Housing Alliance, and this is part 2 of our 3-part fair housing webinar series for housing developers. If you were able to tune in last week, we provided information on fair housing laws. Today we will delve a little deeper into fair housing laws related to disability, and next week, January 21st, we will discuss best practices for affirmatively furthering fair housing. Please remember to register for session 3. Today you will hear from our expert presenter, Ken Walden, who currently serves as managing attorney for the civil rights team at Access Living of Metropolitan Chicago. During the presentation, all attendees will be on mute, and at the end of the presentation, you will have the opportunity to ask questions by typing into the chat box. We will make presentation materials and a recording of today's webinar available on our website. I will now kick it over to Ken for his presentation.
Good afternoon, everyone. We will spend the next 60 minutes or so together, and I will try to provide within that time period some basic information, basic knowledge about the fair housing rights of people with disabilities. Lots of the work during this training will flow from a series of hypotheticals that you will read on your screen. The hypotheticals are based on real cases that we've handled in our office. We will be discussing a number of topics: reasonable accommodations, reasonable modifications, denial of housing, and the like, as well as new construction and rehabilitation. After the training, 2 handouts will be made available to attendees. One has the answers to all the hypotheticals, plus additional hypotheticals, and the is an overview of the new construction requirements under the Fair Housing Act and Section 504 of the Rehabilitation Act. So if you're not inclined to take hurried notes during the presentation, do not despair, because the information that I provide and then some will be in the form of those handouts after the presentation. First, a brief commercial or propaganda about Access Living. Access Living, if you don't know, is a disability rights organization. It's been around upwards of 30-plus years. It's governed and staffed mostly by people with disabilities, meaning that most of the people who work in our office and most of our board members are folks with disabilities. And Access Living has a legal team, which I direct, handles a lot of fair housing cases on behalf of folks with disabilities. As you probably learned from Jessica Schneider last week, the original version of the Fair Housing Act passed in 1968 and covered several protected classes. It covered folks based on race, color, national origin, religion, and gender. But notably, it did not include disabilities at this time. So during the passage of the Fair Housing Act and thereafter, it was under federal law somewhat remarkable that it was perfectly legal for property owners, landlords, managers, and the like to discriminate against people with disabilities under federal law. That changed in 1988 with the passage of the Fair Housing Amendments Act, which included disability among the protected classes against whom housing providers could not discriminate. One of the notable things about the Fair Housing Amendments Act of 1988 that makes the disability provisions so unique is that in addition to the traditional thou shalt not provisions, for example, thou shalt not deny housing to someone based on race, color, national origin, for disabilities, the Fair Housing Amendments Act added some thou shall nots. Thou shalls, pardon me, some thou shalls. Some affirmative obligations of property owners with respect to people with disabilities, which is very different from the other protected classes, and we're going to discuss quite a few of those thou shalls as we move forward with the presentation. All right, then, it's hypothetical time. Whoopee! It's time for hypotheticals. Let's start with the first one, We'll go with Peter first. Again, these are all based on real cases we've had in our office. So let me introduce you to Peter. Peter is a gentleman. He shares custody of a dog with his ex-wife. He lives alone in an apartment building that has a no pets policy. The building has told Peter he cannot keep the dog. However, Peter states he has a psychiatric disability, namely obsessive-compulsive and generalized anxiety disorder. He claims he needs the dog because it provides emotional support that diffuses or lessens his obsessive thinking, especially at night. He's a teacher at a suburban high school. He's also a part-time actor who has appeared in plays throughout the Chicago area. He states he does not take his dog to work or when he is acting. He wants to keep the dog. So I wonder what you're all thinking. At first blush, you might be raising eyebrows at the possibility that Peter can keep the dog. First of all, he doesn't need the dog all the time, apparently. He shares custody of the dog with his ex-spouse. He doesn't bring the dog to work with him. He's a high school teacher. He doesn't even take the dog with him when he's acting or rehearsing. And he only needs the dog at night. And to be frank, when we first got this inquiry from this client, we were kind of skeptical ourselves. But as we looked into the situation a little more deeply, we drilled down a bit, we saw that what was unique about Peter's situation is that he only needs the dog, and this kind of makes sense, when he's alone at night. When he's acting and when he's teaching, he's surrounded by people. When he's alone at home at night, he doesn't have that support. In addition, we realized that lots of disabilities are episodic, meaning they're not present or manifest all the time. Mental illness, autoimmune disabilities, some other physical conditions, and seizures are obviously not always manifest or active within or about a person with a disability at all times. Hence, this was a situation where Peter needed the dog in episodic or selected times, and those times were especially at night when he was home alone. So Peter asks his housing provider if he can keep the dog and explains that he only needs the dog at night because of his disability and only needs the dog occasionally. Is Peter's word good enough in this instance to carry the day? Well, what this gets at is what's a concept called reasonable accommodation. It's a concept that's in the Fair Housing Act, and it essentially says that folks with disabilities are entitled to what are called reasonable accommodations to practices, policies, procedures of a housing provider. That means, in some instances, a person with a disability can get an exception or a waiver of a rule that would otherwise apply to everyone else. And in this instance, of course, it's the no pets policy that is at issue. Here, because Peter's disability is not apparent, in other words, you can't tell by looking at Peter that he has a disability, he would have to provide some type of documentation to prove or demonstrate that the accommodation he asks for, in this instance, an accommodation to the no pets policy that would allow him to keep the dog, is reasonable and necessary. And that's exactly what happened in this case. Peter submitted to us information from his therapist that explained that he only needed the dog at night and occasionally, and this was a direct result of his disability. So in this instance, Peter's documentation is absolutely necessary. A lot of folks ask whether support animals or service animals have to be trained or have to have certain credentials. The answer is a resounding no. They do not need specific credentialing from a special school, a special training center, and the like. And that's just simply a misconception out there in the world. In this instance, it's an emotional support animal. And there are many, many animals that serve as an emotional support animal and don't have any special training and similar backgrounds. Lots of housing providers ask if they can charge pet fees in this instance. The answer is no, even where, let's change the scenario a bit, and let's assume for the moment that Peter's in a building that allows pets, so having the dog is not an issue. But their policy is to charge pet fees for everyone who has a pet. Even in that instance, the pet fee should be waived because Peter needs the dog as an accommodation. But the short thing to know is pet fees under no circumstance are allowed to be charged against a person who needs an accommodation in the form of a service animal. Likewise, housing providers cannot require someone who needs a service animal to pay an additional deposit, pay an increased rent, or to purchase special liability insurance. And furthermore, breed and size restrictions that might otherwise exist at a property that allows pets do not apply when a person with a disability shows that he needs a support animal. Any restrictions on where the dogs can go? We get this question a lot. Sometimes housing providers want to prevent the dog from going into the laundry area or the exercise room and the like. And generally speaking, there are no viable restrictions that can be placed on the dog, although we typically counsel our clients with support animals or service animals to be mindful of other people who might be nervous or scared around dogs and act accordingly. So occasionally there are instances where our clients will agree not to enter an elevator or enter a certain room if there's folks in there they know are scared of dogs. Let's change the scenario and pretend that Peter is a person with a vision disability, has trouble seeing, and relies on a guide dog to ambulate around the world. If the dog is a guide dog, then in that instance, Peter's word rather than documentation carries the day because his disability is apparent and it should be obvious to the housing provider why Peter would need the dog. So in this instance, if the housing provider were to ask Peter to submit documentation to prove that the animal is necessary and reasonable, that would be an inappropriate response by the housing provider. What about other animals? Well, in theory, any other animal can serve the purpose of an emotional support animal or a service animal if they're providing a service that is reasonable and necessary. All right, we're done with Peter. Peter's got his emotional support animal, and now we're moving on to Keisha. And here's Keisha's situation. Keisha has a physical disability. She has lived in her apartment building for several years. Until recently, she relied on a cane or walker to move about. However, her condition has grown worse over time, and she now uses a wheelchair. Because of this, she has great difficulty getting through the main front entrance of the building because it has a couple steps. What can Keisha do? Now this raises the prospect of what's called a reasonable modification. Unlike an accommodation, which is a change to a rule, policy, or practice or procedure of a housing provider, a reasonable modification you should think of in terms of infrastructure, nuts and bolts, concrete and wood. Reasonable modification is an improvement to the unit or the common area, or the removal of kind of a physical barrier that a person with a disability needs in order to access the unit and enjoy equal opportunity. Here, it's kind of obvious, Keisha would need a ramp built up to the front steps so that she can get over it in her wheelchair. That's a classic example of a reasonable modification. It's an improvement to a structure, the kind of the removal of a barrier, the step, that will enable her to get into the building up the front entrance and up the front, through the front door. The question is often raised, who has to pay for the ramp? And there are two scenarios. If Keisha is renting private market housing from a landlord in the private sense, then it's Keisha's responsibility to pay for the ramp, to cover the cost of the ramp. However, if the building is a recipient of federal funds, for example, a local housing authority, then the obligation to pay falls on the housing provider. So again, private housing, Keisha pays. Subsidized housing subsidized by the federal government, the housing provider pays. But can Keisha just, let's assume this is private housing, and Keisha decides she's going to build the ramp. Can she just do so without giving any information to the housing provider? Well, if the housing provider insists, and lots do, and this makes a lot of sense, the housing provider can ask for a reasonable description of the work, reasonable assurances that the work will be performed in a work-person-like manner, and require to see any necessary permits. So beyond Keisha, once asked for that information, to provide it. And that's normally what happens. Who maintains the ramp? Once the ramp is in, as in the slide a few slides ago, once the ramp is in, whose obligation is it to maintain it? If the improvement is to the common area, like in the slide, then the obligation is on the provider to maintain the ramp, for example, removing ice and snow. However, if it's an improvement to the interior of the unit, for example, the installation of a grab bar around the bathtub or shower that Keisha needed, the obligation to maintain that would be on the unit owner, except of course if the grab bar were to come out of the wall or be a structural problem, then the burden would be back on the housing provider to kind of maintain it. But generally speaking, improvements in the common area are the responsibility of the provider, and improvements in the unit are the responsibility of the resident. What if we change the scenario a little bit and Keisha did not yet live in the building, but instead wanted to live in the building or just signed a lease to live in the building and desires to put the ramp in? Is it the same result, or is Keisha kind of out of luck? Short answer is same exact result. You can ask for an accommodation or a modification at any time, and if Keisha were not yet living in the building but needed that modification in order to live there, for example, after she signed the lease, she could ask for the modification, and the provider would be obligated to say, sure, you can put it in. All right, we finished Peter and Keisha. Peter's got his dog. Keisha's got the ramp. Now we turn to Maria. Maria has an autoimmune disability. To treat her condition, Maria takes medication. She lives in an apartment building. One of Maria's medications makes her sleepy. Recently, as a result of taking this medication, Maria fell asleep while cooking something in her oven, and this caused a small fire. Maria woke up in time to call the fire department, which put out the fire. However, the oven was damaged, and there is smoke damage on the walls and ceiling of the kitchen. Due to this incident, management sent a notice to Maria that states it intends to evict her for breach of lease. Is this an accommodation or a modification case? It's an accommodation case. Maria can ask the property management for a reasonable accommodation to its eviction policy because the fire was directly attributable to her disability. However, you might be thinking, whoa, wait a second. She caused a fire. That's a pretty serious thing. Can't we simply discount the reasonable accommodation and move on? And the answer to that is no. Even in an instance like this, management has an obligation to engage and talk with Maria in what's commonly referred to the interactive process in an effort to come up with some solution that would greatly minimize or eliminate the risk. Let me repeat that. Even in instances where the landlord is asserting that a tenant's presence in the unit presents a threat, a direct threat is the language in the statute. Even in those instances, a provider has an obligation, if Maria asks, to interact with her to try to come up with a solution that will resolve the problem in an attempt to accommodate. Here there are a couple solutions. Again, these are based on real cases we've had. One possible solution is that Maria agree to have her oven turned off and not to use it. Alternatively, she can ask the she can try to find out if there's medicine that won't make her sleepy that will address her condition just as well. And if she's able, and if the parties can agree on these things, or if Maria presents evidence that she's now has medication that doesn't make her sleepy, she probably has a good claim for an accommodation and can avoid an eviction. All right, that's Peter, Keisha, and Marie. And now we're with Amber. Amber, who is blind, is interested in a third-floor apartment in a building that does not have an elevator. When Amber shows up to view the unit, the landlord notices Amber's disability. The landlord is concerned that Amber may hurt herself walking up or down 3 flights of stairs, or be unable to exit quickly in an emergency. The landlord is also worried that she may be liable if Amber gets injured. Therefore, the landlord refuses to rent the apartment to Amber. Can the landlord do this? What do you all think? The landlord can't do this. Denying housing to Amber based on her disability is clearly discrimination under the Fair Housing Act. It is Amber's call where she can live, not the housing provider's. Amber has the right to make this decision as to where she wants to live, just like anyone else, free from the provider's arguably paternalistic and discriminatory attitudes about her ability to live in the unit, to ambulate up and down the stairs, and to get out in an emergency. In addition, a landlord's fear of liability is not a legitimate basis to deny housing to a person with a disability. All right, we made short work of Amber. Let's move on to Letitia. Letitia has a physical disability, and she also lives in an apartment building, and she relies on a cane or walker, but sometimes uses a wheelchair. The building has a parking lot for residents, and that includes 3 accessible spaces. Residents are assigned parking spaces. Letitia needs an accessible parking space, but her assigned space is not accessible. 2 of the accessible spaces are used by residents who use a wheelchair, and the remaining accessible space is reserved for guests who have a disability. What can Letitia do? Can Letitia get the accessible space reserved for guests? Absolutely. Again, this is kind of a classic accommodation. She's asking for a change in the policy. She needs an accessible space in order to have an equal opportunity to live in the building, and the housing provider should provide her with the guest space as a permanent assigned space as an accommodation. Some folks wonder whether a parking space is an accommodation or a modification, and the short answer to that is it's considered an accommodation, even though in some instances there may be some work the landlord has to do to make the space happen. And I should mention in light of that if expenses are attendant to an accommodation, but it's on the landlord to provide the accommodation, the landlord has to pay those expenses as long as they are reasonable. And we'll address that in another hypothetical in a few minutes. Let's change the Letitia hypothetical just a tad, but a pretty dramatic tad, and assume there are only 2 accessible spaces in the lot, and both the spaces are used by residents who use wheelchairs. In that instance, what's Letitia to do? Is she kind of SOL? In those instances, what I encourage the parties to do is to think outside the box. And again, the provider, rather than just discount Letitia's request for an accommodation and not interact with her, it's an obligation incumbent upon the housing provider to get together with Letitia and see if there's some way to create a space for her. And in our experience, what we've seen happen when people do this is that with some restriping of the parking lot, rearranging of some spaces, moving dumpsters or other equipment, oftentimes management and the client and the resident can come up with a solution that everybody's satisfied with. It's not always the case, but it's very often the case. Franklin. Franklin, who is deaf, recently moved into an apartment building. He relies on sign language to communicate. Management has planned a welcome to the building party for new residents. Franklin plans to attend. He asks management to provide a sign language interpreter for the party. What do you think? Does Franklin get a sign language interpreter? Whoops. Well, it's a question of equal access. If you think about it, there's no way Franklin can participate in this management party without a sign language interpreter. And lots of housing providers get this wrong. Because it's a management-planned, management-sponsored party, they have an obligation to make sure that Franklin has an equal opportunity to participate. If he needs a sign language interpreter to communicate during the party, then it is the obligation of the housing provider to provide that interpreter. It is not okay to ask Franklin to bring his own interpreter. It's not okay to ask Franklin to bring a relative to interpret for him. It is the obligation of the housing provider to pay for and arrange for the sign language interpreter. Also, you should note that there are services in the city and state that will assign sign language interpreters to you for a period of time. And trust me, it does not break the bank. It may be a few $100s for a few hours of time, but it's what's required by federal law. Oops. Oops. All right, we're going to transition a bit. We're going to take a bit of a turn here, and we're going to start talking about new construction issues. So we're leaving kind of accommodations and modifications and outright refusals to rent, and now moving into the new construction and rehab arena. Again, these are some thou shall requirements. Again, when I spoke in the beginning about thou shall and thou shall not, traditionally, when it comes to protected classes, the obligations are on a housing provider not to do certain things. Not to deny housing, not to give worse terms, not to give worse leases to folks based on their protected class. But with respect to disability, there are a number of thou shalls. Reasonable accommodation, as we discussed, reasonable modification, as we discussed, and now new construction. So here we have Get It Right Real Estate. Get It Right Real Estate is developing a new apartment building in Chicago. It will have 5 floors and 40 units, so 8 units per floor. Get It Right understands the design and construction of the building must comply with federal, state, and local laws regarding accessibility. How can Get It Right get it right? The most important thing I can recommend is that you secure an architect with expertise in the area of accessibility. I think it's dangerous to proceed with a big project without having an architect on hand or an architect to consult with who has expertise on the accessibility provisions of the Fair Housing Act, Section 504 of the Rehabilitation Act, if federal funding is involved, the Illinois Accessibility Code, and any relevant local code, for example, the Chicago Building Code. On to the Fair Housing Act. Again, this is a very basic description of the requirements, but I'll go through the basic new construction provisions of the Fair Housing Act. But again, you should really secure an architect with expertise. I'm just going to kind of brush the surface of what's required. All right, so what does the Fair Housing Act's new construction provisions apply to? What's covered under that act? It covers new buildings, new residential buildings with 4 or more units. New residential buildings with 4 or more units. Is an elevator required in new buildings, new residential buildings with 4 or more units? No, an elevator is not required. However, if there is an elevator, all the units on all floors must be accessible. If there's not an elevator, then only the ground floor units must be accessible. So if you have 4 more units, the Fair Housing Act, 4 more residential units, the Fair Housing Act kicks in. There's no requirement for an elevator. If you have an elevator, all units must be accessible. If there's not an elevator, just the first floor, ground floor. Whoops. Why is it doing this? Hold on a second. There we go. All right. There are 7 basic requirements under the Fair Housing Act's new construction provisions. The first requirement is that the building have an accessible building entrance on an accessible route. An accessible building entrance on an accessible route. The accessible building entrance has to be the primary entrance, has to have a 32-inch clear width opening, usable door hardware, and accessible running and cross slopes. Accessible route, there has to be at least one, connects everything within and about the building. Mailbox areas, laundry rooms, garbage areas, etc. Again, don't worry about taking copious notes. All this information will be available in the new construction handout that's distributed after this training. All right, so that's requirement number 1, accessible building entrance on an accessible route. Number 2, accessible common areas. All common areas, all public use and common areas have to have certain attributes of accessibility. That includes parking areas. At least 2% of parking spaces have to be accessible parking spaces. At least 2% of parking spaces have to be accessible parking spaces. Requirement number 3, usable doors. Usable doors. Usable doors are defined as 18 inches of clear floor space on the pull side of the door, passable thresholds, usable hardware, and clear width openings. For the door into a unit, the clear width opening has to be 36 inches. The clear width opening into a common area has to be 32 inches, and within a unit has to be 32 inches as well. And there has to be usable hardware, which is usually lever type hardware of the kind pictured on the slide. And that's required everywhere except within the unit. So usable hardware is required for the door into the unit, into the building, common areas, but not for doors within the unit. So far, we know the 3 requirements are accessible route into the building, accessible entrance, accessible common and public use areas, usable doors. Let's move on to 4. Requirement number 4 is an accessible route into and through the unit, into and through the specific apartment unit. This includes such things as hallways that are at least 36 inches wide, and turning space so that someone in a wheelchair can make turns into and around certain hallways and rooms. Accessible route into and through the unit is required. Number 5, accessible controls, accessible light switches, electrical outlets, and thermostats, among others, accessible controls. And what that means is they should be placed no lower than 15 inches from the ground and no higher than 48 inches from the ground. So in the neighborhood of 15 to 48 inches, and you're spot on. So that's requirement number 5, accessible controls. Number 6, requirement involves reinforced bathroom walls. Reinforced bathroom walls for the possible later installation of grab bars. Let me repeat that. Reinforced bathroom walls for the later possible installation of grab bars. What that means is the walls have to be reinforced so that in the event a person moves in who needs grab bars installed, those walls are already reinforced and can support the installation of grab bars. But there's no obligation on the provider to design and construct a building that already has the grab bars. However, they are required to build bathrooms that have reinforced walls. Lots of providers get this wrong, but it is one of the key requirements of the Act. The exception to the grab bar rule is this: if there are going to be public restrooms in the building, then in addition to reinforcing the walls, the developer has to install grab bars. So in public bathrooms they have to be installed, but in unit bathrooms the requirement is merely, or not merely, is to reinforce the walls. That's number 6, reinforced bathroom walls. And last but not least, for the 7 technical requirements, the last one is referred to as usable kitchens and bathrooms. Usable kitchens and bathrooms. Again, the specs for these are included in the handout you'll get after the presentation, but the more specific technical requirements you can find elsewhere, and we'll talk about that in a few minutes. A usable kitchen is defined as a kitchen having sufficient clear space at appliances. Clear floor space is defined as 30 inches by 48 inches unobstructed, and sufficient clearance between fixtures. So sufficient floor space, clear floor space, and sufficient clearance between fixtures. Usable bathroom. First, know that a bathroom is defined as including a toilet, sink, bathtub, or shower. Toilet, sink, bathtub, or shower. And there are 2 accessible bathroom options, Type A and Type B, which we're not going to go into, but you'll see those described in the handout. But a usable bathroom is defined as one having clear floor space within the bathroom and at bathroom fixtures outside the swing of the door. Clear floor space within the bathroom and at bathroom fixtures outside the swing of the door. And the clear floor spaces may, in this instance, overlap. So those are the 7 technical requirements under the Fair Housing Act's new construction thou shall provisions. So how does one know if they're complying with the Fair Housing Act's new construction thou shall provisions? HUD has approved what are called safe harbors. Safe harbors are building codes that developers and architects can rely on. And if they comply with those safe harbors, then they have complied with the Fair Housing Act in the eyes of HUD. The most common safe harbors relied upon include the Fair Housing Act Guidelines and Supplemental Notice, the Design Manual, and American National Standards Institute, ANSI, used in conjunction with the Act, the Act's regulations, and the guidelines. Those are some of the most common safe harbors relied upon. And they outline precisely what the requirements are for all the 7 technical requirements, which we spent a mere 10 minutes or so discussing. All right, we're going to switch gears now, and we're going to talk about Section 504 of the Rehabilitation Act. Section 504 of the Rehabilitation Act. It applies to new public and government subsidized housing in 3 different scenarios. So this Act, Section 504 of the Rehab Act, has new construction provisions that apply to public and government subsidized housing, and there are 3 different scenarios. Part 1 is brand spanking new public housing and government subsidized housing with 5 or more units. So if a new public housing authority, if a housing authority is building a new public housing site and it has 5 or more units, the Section 504 provisions, the new construction provisions of it, must be complied with. So that's one scenario. A second scenario is if there are new renovations to public housing and government subsidized housing, new renovations to government housing and public housing that are substantial, and substantial is a term of art defined in the Act or in the regulations. It's a term of art and has to do with the percentage that I don't want to get into for purposes of a short training, but if substantial renovations are going to occur, if substantial alterations are going to occur involving 15 or more units in a building with 15 or more units, then the new construction provisions kick in. And then finally, scenario number 3, newly renovated public housing and government subsidized housing where the alterations are not substantial also kick in some new construction requirements. So even where these renovations or alterations are not substantial, there are still obligations on the housing provider where there are 5 or more units to comply with some new construction requirements. Again, this is a little confusing, and I urge you, again, to refer to the handout and the specific codes. Among the requirements, though, that are most important is that when new public housing is being built or renovated, 5% of the units must be accessible and usable to people with disabilities, with physical disabilities. And unlike the Fair Housing Act, these requirements are a bit more strict. So for the 5% of units that have to be accessible and usable for people with mobility disabilities, there are certain adaptability features that must be built into the units. For example, the kitchen counters and sinks, so that those particular elements are capable of modification to accommodate a person with a disability with ease. So again, the 5% of units that are required to be accessible and usable under the Section 504 requirements include provisions that are more strict than the Fair Housing Act requirements we discussed moments ago. Likewise, 2% of the units have to be accessible and usable to people with hearing or vision disabilities, and again that means they have to be adaptable. So one of the common things that a housing provider would be required to do if they have to comply with 504 is to include wiring in the walls for the possible installation later of visible emergency alarms for someone who is deaf. So again, the 5% and 2% of units that are affected by 504 have to have features that go above and beyond the Fair Housing Act's general technical requirements. What standards apply for Section 504 compliance? The Uniform Federal Accessibility Standards. And again, these are stricter requirements than the Fair Housing Act. All right, so if anyone's confused, I'm going to try to address that confusion right now. We'll use our last hypothetical. Make no mistake, real estate is developing a new apartment building in Chicago. It will have 5 floors, 40 units, and 2 elevators. Make no mistake is receiving federal funds to ensure a number of the units are affordable for persons of low income. Make no mistake understands the design and construction of the building must comply with federal, state, and local laws regarding accessibility. How can make no mistake make no mistake? Well, here's the math. There's 40 units. All 40 must comply with the 7 general requirements of the Fair Housing Act. Remember, the Fair Housing Act applies to any building with 4 or more units, even if it's a subsidized building or private building or whatever. If it's a new residential unit with 4 or more units, the 7 general requirements under the Fair Housing Act have to be complied with. So all 40 have to have the attributes we described several minutes ago. Because federal funding is involved here, 5% here, 2, 5% of 40 is 2, of the units must be accessible to and usable by persons with mobility disabilities. And again, that means 5% of the units have to be for lack of a better description, especially accessible for people with mobility disabilities. And 2% have to be especially accessible by persons who with hearing or vision disabilities. Hearing or vision disabilities. In the 2%, I say 1 because the requirement is at least 2%, is 2% or at least 1. So 2% of 40 is less than 1, but you have to have at least 1 in the 40-unit building. But don't forget, make no mistake, must also comply with the Illinois Accessibility Code and any relevant local codes, such as the Chicago Building Code. So that gets back to the point I wanted to emphasize at the very beginning, and I'll emphasize it here at the end. If you're going to be rehabbing property that's subsidized, you're building a new residential building with 4 more units, if you're building a completely new subsidized building, the most important advice I can give you is to secure an architect with expertise on the Fair Housing Act, Section 504 of the Rehab Act, Building Code, and the Chicago Building Code, or another local code that's relevant in order to make sure you comply with all the relevant requirements. So that concludes the substantive part of the training, and I'd be happy in the time remaining. It looks like we have about 12-13 minutes to answer any questions. Sometimes it takes a few minutes for the questions to transfer here, so please hold on. First question, can you provide any examples of claims requested by tenants that were rejected and why? Can you provide any examples of claims requested by tenants that were rejected and why? Sure, we certainly have had cases where folks who wanted to keep an animal were not able to persuade us, and therefore we didn't think they'd be able to persuade their housing provider that the animal was a support animal. We've had cases like that where if we don't have the evidence to support it, and usually that evidence is in the form of a medical provider, a therapist, psychologist, psychiatrist, and the like, then those claims don't win. We've had claims before, people wanting to break a lease early, but couldn't really show that it was nothing more really than a matter of convenience and that they didn't really need it for purposes of their disability. But on the other hand, we've had lots of cases where folks, because of a disability, needed to break a lease early. Recently we had a case where someone's condition worsened to the point that they could no longer live in the unit, and the housing provider, to their credit, we were able to negotiate an agreement to let the person out of the lease early without penalty. Good question. Are there ever financial incentives for developers for buildings that go beyond the basic requirements? Are there ever financial incentives for developers for buildings that go beyond the basic requirements? That's a good question. The short answer is I don't know, but I suspect the Illinois Housing Development Authority, that State Department probably can tell you whether or not there are financial incentives to go beyond the basic requirements. Offhand, I don't know for sure. Is accessibility addressed at all in the new HUD AFFH rule? It is, and the new, for folks who don't know, the AFFH rule, it's a rule that HUD recently kind of updated, and it requires jurisdictions that receive certain pots of federal funding to affirmatively further for housing, meaning to make an effort to ensure that folks within their jurisdiction really have and truly have an equal opportunity to live in the housing that they choose and can afford. And accessibility and disability is certainly a part of that, as are all the other protected classes. And so yes, it is addressed in that new AFFH rule for sure, both in the rule and in the assessment tool that accompanies the rule. If your question is whether there are specific accessibility provisions in the new AFFH rule, no. The accessibility provisions that you need to be mindful of are the Fair Housing Act, Section 504, the Illinois Accessibility Code, and any local codes. All right, we'll give one more minute for any additional questions. How does the Olmstead decision relate? For folks who don't know, the Supreme Court several years ago issued a decision called the Olmstead decision that that found that the unnecessary institutionalization of people with disabilities violated the Americans with Disabilities Act. And it required states to make efforts to transition folks who are living in institutions into community-based settings with support services that, in addition to being the right thing to do, saves the state a boatload of money. The Olmstead decision relates to the accessibility provisions that the new construction provisions and other things, the other rights attendant to the Fair Housing Act, because as people with disabilities have moved, continue to move, and will move as required under this Olmstead decision, they're going to need housing. Lots of them will need accessible housing. Lots of them will need accommodations. Lots of them will need modifications. And lots of them will just need the opportunity to live in the unit of their choice without kind of prejudice or discrimination, as in the Amber hypothetical. So the extent to which housing providers, developers, architects, property managers, landlords, and the like comply with their obligations under the Fair Housing Act, that will be met with the ability for people with disabilities to get out of institutions and secure housing. So there is kind of a direct correlation between the Fair Housing Act requirements and the Olmstead requirement that states move people out of institutions. What is the ADA and how is it relevant? So the Americans with Disabilities Act was passed in 1990. For the most part, and this is a great misconception, for the most part, it does not cover housing. There's some little exceptions to that, but for the most part, the ADA does not cover housing. The ADA has three principal titles. It prohibits discrimination in employment against people with disabilities, prohibits state and local governments from discriminating against people with disabilities, and it prohibits discrimination by public accommodations, basically businesses that are open to the public from discriminating. And like the Fair Housing Act, it has lots of thou shall provisions regarding accommodations, modifications, and new construction. The ADA, for the most part, is not relevant to fair housing. It is in a slight way, but for the most part, it's really not. And for your purposes, I don't think you have to worry about it much. One example is the property management office of a housing provider would be covered by the ADA rather than the FHA, the Fair Housing Act. But the ADA covers a lot of other infrastructure and rights out in the world, but it, for the most part, does not cover fair housing because that was already covered by the Fair Housing Act when the ADA was passed in 1990. We probably have time for one more question. And we'll give it another minute. All right, folks, thank you very much for your time. I hope this was worthwhile. And we are going to end the webinar. Thank you so much. Have a good day.
Thank you, Ken, and thank you for joining us today. Remember to register for Session 3 on best practices related to affirmatively furthering fair housing, which will take place next Thursday. Also, an email from me providing a link to materials and a recording from today, so look out for that. Thank you to Illinois Legal Aid Online for their assistance. This webinar was made possible by a grant from the Illinois Attorney General. Thank you, and see you next week.